going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Shipkey, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Friday night. Hope everybody's well. I see the chat rolling. You guys are all awesome. Sorry I haven't been around much today. Kind of been taking a little bit of a me day. It's been a rough day. We'll just keep it at that. All right. You guys want to watch some cord? Let's watch some cord. Before I hit that play button, you already know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Mess it up.
Morning, Your Honor.
All right,
Cheryl, walk
state-
up on behalf of the plaintiff.
State your name, sir.
Jack Wazork.
Okay. And where are we on this? Was this his motion?
Your Honor, I don't think he can argue the motion. There was a motion filed that was drafted clearly by legal aid, but signed by Mr. Wazorek. This was a health hazard due to bed bugs and roaches and the landlord not being able to access the premises and the premises not being available denying entry and not being prepped. We took a default judgment, and I know Your Honor wanted to review this, and that's where we were last week. It's landlord's
Right.
position. Go ahead.
Go ahead.
I was just say it's landlord's position. We want possession of the premises. We've had chronic issues with housekeeping, cleanliness. It's not fair to the other residents. This is an ongoing problem. I'm very willing and ready to argue that Park Forest does not apply to a health hazard. So I'm going to leave it to you what you want to hear, but I am strongly requesting a judgment here to stand.
Sir, go ahead.
Your Honor, I have had RPI in there twice inspecting my place. They never came in.
They being who?
Arbor One
Okay.
never came in. Wendy, the assistant manager, I told her that wasn't a problem. The garbage bags, like I told you last week, were not garbage. They described them as garbage. Those were pots and pans and stuff we had to put in the bags because they wanted to do a cockroach inspection. 6.5 years, I've never seen a cockroach. They turned it into, well, it's garbage. There's garbage all over the house. They never brought anybody in. I had paid a lady, a friend of mine, $100 after that to come in and make sure everything was in line. You got an affidavit from legal aid showing that RPI been in there twice and gave me a pass inspection. They passed me twice. Arbor One has never come in to my house. Wendy told me she got the report on a Friday. She said she'd have somebody in there Monday. Nobody ever showed up at all to do an inspection at all. I had to call RPI when I got the court judgment and bring them in on it, which I told Arbor One, I told the assistant manager, Wendy, I wouldn't get Arbor One into it if we could help it. She wouldn't let it go. I've been having problems with maintenance in there since 6.5 years. I've been having problems with maintenance. All I'm trying to do is keep a good place. RPI come in there twice. They said the inspection passed inspection. So they never come in. Arbor One never came in and did any kind of inspection at all.
Your
They
Honor,
just
if I
went
may just
by-
respond to this. First of all, I don't know what affidavit Mr. Wazorek is talking about. Second of all, we're talking apples and oranges here. We're not talking about RPI. We're talking about bed bugs. We're talking about the treatment provider came to the unit on 2-2, was denied access, and then
But
came
that
back
wasn't,
of the
That
hearing.
wasn't the original
Sir,
judgment.
Judge
sir,
Barr.
I can. let Ms. Luckoff go. I let you go for a while. I just want to, go ahead, Ms. Luckoff.
Linda, thank you so much for becoming a new member. Yes, you are a member now. Welcome. Members only content every Monday. Couple days away. We have fun. Come hang out with us.
The date of the hearing in front of Judge Barr, they were again denied entry. This is, and there are bed bugs in the unit. And that's not, this is multifamily living. I don't have to tell the court, that's not fair to the other residents. So we are asking that the judgment stand and we recover possession of the unit.
Your Honor, they
Sir,
called me
sir, what affidavit? Because I don't
because there
have,
was
I
one
don't
from-
have an affidavit either.
There's one from legal aid. They sent you a paperwork over. They sent you a bunch of paperwork over.
Who did?
In legal aid,
Sent me?
yes. Yes. That's who I received my, that I was supposed to see you about.
Sir, hold on a moment. The only thing that I've received that I have in the court file, the only thing that I've received was the motion to set aside default supplement. And that's the document that's signed.
I have all the paperwork in my briefcase that I can show you.
Okay, but sir, did you let the treatment providers in?
They were told,
That's a yes or no.
yes.
When you
Not,
let them,
not at the time that they actually came the first two times when we were in court. Excuse me, Your Honor, but it's important that this is clarified. On the second, they were denied entry, and then on the court hearing date, which would have been the 16th, they were denied entry.
I
So
never denied
after the
them
fact,
entry.
All
after
that-
the judgment was entered, they were permitted entry.
No,
Because
they were
I never
denied-
them
Obligation.
sir. They were denied entry on the 2nd and the 16th,
correct.
or the, yeah, the
And that's the
16th.
date of the hearing was the 16th.
Incorrect.
So did they come in on the 2nd, sir?
No, they talked to my son at the office. And he told them we weren't ready at that time. He wasn't
Okay,
part of that.
that's a denial of entry.
I never denied him entry.
Well,
They never
Not-
came to my door,
if you're not ready for the treatment, that's a denial of entry.
but that was through my son, not
On the
me.
16th,
On the 16th, I told him he could come in. I told him inspect if you want. I said, could you wait off for a couple hours? I'm at court with Zoom, on Zoom with the other court.
so
with the
they
other
were,
officer,
so
with the other
hold on a
judge.
second, sir. So what I'm hearing you tell me is that on that date, the unit wasn't ready to be sprayed either.
Yes, it was ready to be sprayed. We
Then-
just had.
Then
to-
why were you asking them to wait?
Just because I was in court at court at that time. And they never gave me no warning that he was showing up or coming. It's supposed to take 24 hours notice. I didn't get no notice. They
That's
just
such-
popped in the door. I had to go to court on Zoom with the other judge. I was there. I did not deny them entry. I told them, yes, if you want to come in and inspect, come on, inspect. I said, but can you wait until a couple hours to spray till I'm done with court? They don't give me no time. They want to do it when they want to do it. They want to just.
Exactly, sir.
Oh.
Exactly, sir. They needed to come in and do the treatment.
But they don't understand that we have a house, we have to maintain ourselves. And when I'm on court, on Zoom, on the phone, all I'm asking for, I'll move out. I just need more time.
That's what
But
he
that's
said 2
what they
weeks
want.
ago.
If they want me to move out, I'll move.
Phil, don't thank me. Those are free. I get to donate 10 free memberships a month. So that was just 5 that I could donate. I saw someone saying, how do you get a gifted membership? Hopefully they got one of them. I can't see who got them from my side, but for everyone who got them, welcome.
Move out. I just need more time to do it. Because see, the assistant manager, I don't know if this lawyer knows it or not, but they called.
When are you gonna move?
I don't know yet.
Okay, let me put it to you real straightforward. I've listened to what you've told me. I've looked at everything in the file, and both of those 2 times would be considered a denial of entry for treatment of the premises.
But yeah, that didn't even start with the bed bugs at all.
Sir, if you can argue with me all you want, I'm telling you what I'm finding.
Well, do I have a right to get a lawyer or go to trial with this? Because this ain't right. This is not right. I've been haunted by this company for maintenance. The first
Sir,
maintenance
sir,
problem
sir,
started years ago.
Sir, I'm explaining to you what my finding is. Now, if you want, you have a lot of opportunities to do what you want to do. I don't have a problem with that. All right, I'm explaining to you what my findings are. Understood? Is that a yes?
Yes, yes.
So what I'm trying to find in that the Judge Barr found that they were entitled to that, the writ should be signed. You have indicated to me that you will move, but that you needed time. So my question to you is, how much time did you need to move?
At least till like June.
Well, that's not gonna happen.
Okay, because what it is Wendy, their assistant manager, called me last night at 7 o'clock and told me the lawyer told them they were coming in to exterminate today. I told him, yeah. I said, I'm not going to be there. I'm going to be at court. But they have access to come in and spray. And I'm asking, why would they do that if they're going to want us out anyways?
Because the problem that's causes problems for all of the other residents. If your unit doesn't get exterminated, everybody else in that building has a problem.
Yeah, sorry, Kevin. I tried. I saw you asked, and I've got 10 a month, so I'll donate 5 today, and I'll donate the other 5 like halfway through the month. But yeah, just come hang around. People donate. People are very generous and donate memberships all the time. So just hang around a little bit, you'll get one. Also, I see a lot of landlord-tenant kind of comments going on. You know who's awesome at landlord-tenants? Judge Slavin. Judge Slavin will be live on my stream on Monday night. So if you guys have landlord-tenant questions, bring them. Bring them to the stream.
That's why.
Right, I understand that. I understand that. I've been self-exterminating myself before they ever showed up. I was self-exterminating with Orthox or whatever it is. I paid $20 a gallon for it. It didn't totally eliminate it. And I know what the problem is. I have to get rid of my couch. My couch is a major problem with them. And I'm getting rid of the couch this month. I needed money to buy another couch.
All right, Kevin, it shows me green on my screen now. It doesn't, I can't see that if you got one of the memberships because I'm not on YouTube, I'm on StreamYard. But your name is green all of a sudden. We got memberships coming in like crazy. You guys are all awesome. You guys are all awesome. So let's go through this. Flying Monkey donated 5, Jude Curio donated 5, and Kathy donated 5. All 3 of you are amazing. Thank you so much. He got a membership, so membership Monday. Because I have Judge Slavin on Monday night, I'm gonna do membership Monday early afternoon instead of in the evening. So I don't want to restrict Judge Slavin just members. So yeah, membership Monday will happen probably, but yes, 1, 2, 3, I don't know, somewhere around there. But yeah. All right, let's finish this clip. This guy though, I kind of, part of me feels bad for him. The other part of me feels bad for the landlord. A lot of me feels bad for the tenants that live around him though. Like that's not good, man.
Couch. And that's a major problem. It's right there. They're all in couch. There's nowhere else in the house that they're accumulating that, just in there. And the other problem is the people that moved out before me in the building across the hall, they moved out 3 months before everyone discovered they moved, and they had to remove their couch and love seat because they left it behind.
Okay. All of that's fine. The problem is that the landlord,
Slavin does landlord every single day. Every single day. Judge Shackelford doesn't do a lot of landlord tenants. And it's very clear that she doesn't do a lot of them. He gets 90% of the landlord tenants. So if you ever check into one of his dockets, he's doing landlord tenants. It's turned into almost the main thing he does over the last month and a half. And it's I don't like landlord tenant dockets unless they're interesting like this one where someone's yelling. But landlord tenant cases are generally pretty boring to me. I just don't find them interesting.
you objected when you came in here to the hearing that took place before Judge Barr. That's what you were giving me, which is the only reason that I set this where I did. The problem here is that there was a denial of entry to the premises.
But that one you're
For
on the
treatment.
court docket.
It just is. It is what it is, sir.
But Your Honor, what I'm trying to say though is through the original judgment, it was over garbage bags. It wasn't over bed bugs. And they said we didn't prep for the bed bugs the first time. When they gave the court order, they never gave me a prep sheet. They never told me. They said, oh, go back to your prep sheet in December. We never got a prep sheet in December at all. They started this in January, and they said, go back to your prep sheet you got in December to prep it. Well, I never got no prep sheet on bed bugs. We get a prep sheet on cockroaches, which is total different prep. It's a total different prep for cockroaches and bed bugs. We never received a prep sheet for bed bugs, so we didn't know what to prep. So how could I bring them in and say, yeah, we'll prep, when I don't have a prep sheet to know how to prep it or what they want for prep? And even the exterminator came in there and I asked him, are you doing bed bugs and cockroaches? He said, no. He said, I didn't even get a work order on bed bugs. They didn't even get a work order on it.
Your Honor,
Sir,
you want
let me
to
just
stop?
say this. Every time I tell you what I'm finding, you keep telling me something new. It doesn't work that way.
But you're going to
I'm
only
dealing-
2 times, Your Honor. They're going to, you're only going to 2
Now,
times.
You can keep interrupting me all you want.
I'm sorry. I'm sorry.
It's not going to change my decision.
I'm sorry. It's just,
There was a hearing that was held on this. The hearing, I don't find a defect in the hearing. I don't find a defect in the hearing. The judgment will stand, the writ will issue.
how long?
I'm done. The writ issues. It's the statutory, there's no period, sir. There was a hearing that was held.
Well, how long do I have to move? I'm saying, how long are they going to give me time?
I just signed the writ, sir. So you're operating on borrowed time.
Well, because I'm going to lose my Section 8. If this writ goes through, I lose my Section 8. And I have no other way of paying my rent or anything. I've been there 6.5 years. Paid my rent, never gave a problem at all to them. And because of bed bugs, they're supposed to eliminate. I'm being accused of something I didn't even do. I haven't even done anything that is causes warrant for me to be evicted. That's why I'm asking. I just need a little more time, yeah. You know, I need at least a month. And now, if they're causing on a writ, that means they're evicting me. No place is going to touch me with an eviction. You understand what I'm saying? I go to some place, tell them, oh, I got evicted. I'm hit. I'm 60 years old. I don't have time for that. I was trying to retire. I told him up front, I would work with him on stuff. I said, no problem. I'll work with it. We got to work with it, work with it. Yeah, I don't know what else to say. I was never given a lawyer. I have to sit here and defend a lawyer when I don't have that kind of smarts. You know, I'm not that smart to deal with a lawyer. You know, and I'm not even given a chance to for a.
Sir, do not come before me and tell me that as a tenant, you're not given a chance, not before me, because that doesn't happen before me.
Your Honor, I called a lawyer. They said they didn't have a lawyer for me.
Sir, you have interrupted me constantly through these proceedings.
I'm sorry.
Now are intending.
I apologize.
No, do not interrupt me again. You now want to insult me by saying that somehow or another you don't get a fair hearing when you came here. When you came here the first time, I told you what I would do. I read your motion. I went through everything to see whether or not there had been something, because you claimed a number of defects. I then bring you back here, have treated you fairly, have listened to everything you have said. And how dare you say to this court that somehow and or another you don't get a fair hearing for me? I've made my ruling. I'm done. Thank you. I'd suggest that you close your mouth as you leave, because otherwise you're going to be going with my bailiff.
Steps out.
I advise you close your mouth as you leave. You'll be going with my bailiff. Buffliff was ready. Buffliff was ready. Sorry, guys. I know I sound a little unenergetic tonight. I've had a rough day today, so I appreciate you guys all being awesome. I really do. It's just been a hard day. So let's keep watching court and let's have some fun together, right? Right? Let's do it.
People.
Good morning, Your Honor. Christina Costantino appearing on behalf of Ms. Gibbs. Ms. Gibbs, if you're present, please unmute and state your name for the record.
Cynthia Gibbs. Ms. Gibbs, please turn on your screen. Ms. Gibbs, please turn on your screen. All right, we're here for what is supposed to be. We're here for what is supposed to be sentencing, and the defendant has failed to get her report done. In addition to that, I found out that she has been rude to staff. Do you have a copy of the report, Ms. Constantino?
Judge, I don't know that I've received a copy of the report, although I am aware of those two things that you just indicated. I do have some answers as it relates to the substance abuse evaluation. If I could enlighten the court a bit on that.
You may say whatever you need to say at this time.
Thank you, Judge. It's my understanding that my client was informed that there is a $160 fee to complete the substance abuse evaluation. She unfortunately does not have the financial resources to pay that fee. She contacted the substance abuse evaluator and tried to work out a payment plan. The substance abuse evaluator indicated there would be no payment plans available to her. I personally contacted both the court, probation, and the public defender's office to see if there was any way that we could possibly get some either funding assistance or assistance with placing her on a payment plan so that she could complete the substance abuse evaluation. Unfortunately, I have not been able to find any alternative means of funding to pay for that evaluation for her. She since then has just recently, as of last week, obtained some financial assistance from a family member who is willing to pay for that evaluation for her. She contacted the evaluator last week and informed them that she did have the funds, but the evaluator told her that it was too late, given that it was supposed to be completed by, I believe, January 22nd. But if the court would permit her one more opportunity to complete the evaluation, she does now have the financial means to do so via a family member. We understand this is now the second date we are before you, but it does appear that she has the financial means now to complete that evaluation.
Ms. McDuffie?
Nothing from the people, Your Honor. I'll leave that to the court. I understand Ms. Joseph Constantino just addressed the no-show aspect of it. The rudeness to the probation coordinator, I think, was probably next to be addressed.
Yes, Judge. I did speak with my client about her demeanor towards court staff. We had a very lengthy discussion about that and how inappropriate it is to be rude to anyone, especially someone in court staff that's trying to assist her with getting her matter resolved. She was apologetic when I spoke with her about it and indicated she was simply frustrated, but understands she cannot take her frustration out on anyone, especially court staff. I have discussed it with my client. I have advised her that she should absolutely not speak to anyone in a rude manner whatsoever, especially court staff. I believe she does understand that, and we did have a discussion for that. There's absolutely no excuse or explanation for it other than, to tell you, Judge, that we've discussed it and I have hopefully addressed it.
Yeah, I've said this a bunch of times. Don't yell at the court staff. Do not yell at the court staff. They are lovely people. I've said this story before, but I've called a bunch of different courts asking different questions, and they've always been overly nice to me. Why are we yelling at court staff? But why I'm paused, Debbie, I know I highlighted it. I don't think I thanked you, but thank you so much, Debbie, for the 1 month. That's awesome. Thank you so much. Legal Fiction, first super chat of the month. Thank you so much for the $20 super chat. It's very generous. And Sly with the PayPal. The PayPal helps me more than you know, Sly. Thank you so much. Thank you so much. Yeah, I just did. No.
Sorry, what did you say, Ms. Gibbs?
I was talking to my son, showing him where his cup was.
Ms. Gibbs, when you came in this morning, you took a while to turn on your screen and then it went black for a while when I told you to turn it on. It seems that you have some sort of attitude towards the court and towards the court staff. You've been given 2 opportunities to get this done, and you have failed to do so. I am considering whether I should just remand you to the Washtenaw County Jail so that we can get it done there, and then we don't have to worry about you having a bad attitude.
I had a bad attitude because of how I was getting talked to because I missed my appointment. And I was trying to explain to the lady the situation and she wasn't trying to hear me out. It wasn't that I just came on the phone and just had a bad attitude.
No. That is not how you represent yourself. I had a bad attitude because, no, you're being called out for a bad attitude. This is what you say. You know what? You're right. I'm sorry. I was frustrated. I shouldn't have treated the court staff that way. I was having a bad day. Don't even have to go into details about why you're having a bad day. You apologize. You take responsibility for it. You move on. Don't. An apology with the word "but" in it isn't an apology. It's not. I'm sorry. I'm really sorry that I had a bad attitude, but I was upset by how I was treated. That's not an apology. You're not apologizing.
And Judge, I understand the court is considering imposing jail time. I would like the court to know that Ms. Gibbs is a single mother to 4 children who she essentially has no one else to assist her with any care for them. And so we'd ask the court to consider giving her one more opportunity in order to complete this and show the court that she is going to be respectful going forward.
She's
I'm so sorry to hear that. Isn't that special? I am so sorry to hear that. All right. You know what? Let's both change our spirits for the video tonight. I'm tired. I'm just not into the video. I almost canceled it because of my day today. But I wanted to put it out because I appreciate you guys and you guys make me feel better. So let's both enjoy the community together. Isn't that special? And yeah, we'll build up each other. But I'm so sorry to hear about that. That's terrible. I'm sorry.
still in programming for circuit court.
Judge, I don't believe so, but it's my understanding she did on her own enroll in counseling. Is that correct, Ms. Gibbs?
Yes.
What happened to the circuit court programming?
I believe she successfully completed that. Is that correct, Ms. Gibbs?
Yes.
So on her own, over the last few weeks, she enrolled herself in counseling.
What type of counseling?
I would have to defer to Ms. Gibbs for the specifics on it. Ms. Gibbs.
I'm sorry to interrupt. It shows that she's in warrant status in circuit court, but I think for collection. So I just wanted to make sure you were aware of it.
Thank you. I was not aware it was in warrant status, but thank you for letting me know.
What type of counseling are you in, Ms. Gibbs?
I go to Catholic Social Services.
Is that personal counseling? What type of counseling is that, ma'am?
It's personal counseling.
All right, the defendant is to pay for and schedule the interview within 48 hours. If she does not comply, bench warrant will issue.
Thank you, Judge. Thank you, Judge. Have a good rest of your day.
Wait, I gotta give you a new
Oh,
court
sorry.
date.
We do need that.
Your next court date will be March 14th, 2024 at 10 o'clock a.m. in person.
And Judge, I apologize. I'm not available in person that date. Is there any other date earlier that week or at the end of the following week?
About March 21st.
That works, Judge. Thank you very much.
March 21st, 2024 at 10 in person. I'm sorry.
Thank you, Judge.
I'm sorry, 1 second. That would be 11. I don't want you to wait for an hour or more before I'm able to follow.
Thank you, Judge. I appreciate that.
11 a.m. in person.
All right, yeah. The defendant hung up. I don't know if you saw that. The defendant hung up. All right. We're gonna turn this frown upside down. We're gonna get, we're gonna get pumped up. Like this is fun. Like we're here, we're hanging out together. I did have a bad day. So what? There's people that had a lot worse days than me. Which we just found out. So let's change this. Alicia, thank you so much for becoming a member. I very much appreciate it. Members only Monday. So yeah, we're a couple days away from another members only day. Also, Mary Brown, Thank you for the $5 super chat. Very much appreciated. How do I there's two ways. You can either email me or you can Discord me. That's pretty much how I do it. I'm on Discord almost all day long. And my email is in my about page, so you can find it. But thank you so much. Sorry. I just it doesn't matter. But thank you so much for the $5 super chat. All right. Let's go. Trying to change this my attitude. Let's go. Hold on. You know what? Let's start over. This is how we're gonna do it. This is how we're gonna do it for the rest of the video. You guys ready for this? I am ready, but we're gonna do it this way. I think you guys are gonna appreciate this. You ready? What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. Happy Friday. How's everybody doing? Glad to see you all here. We are starting over. We are starting this night over. I am not going to come in here with a poor attitude. You guys don't deserve that. We're hanging out. We're having fun. Everybody's having fun. Let's enjoy the night. Thank you so much, Flying Monkey, for the 5 gifted memberships. And welcome to all the 5 people that just got the memberships. Flying Monkey, you're awesome. Everybody's awesome. Let's keep watching some court clips. Let's go.
Just on a roll, man. Court calls a case of People versus Kevin Rochette.
Oh, this is the perfect clip to change that frown upside down. There's nothing exciting about court that's going on here except for Judge Simpson messing with people for about 5 straight minutes. That's all this is. He's just going to mess with the attorneys for about 5 straight minutes. And that's all this is. This was a perfect way to rejuvenate the night. Let's go.
Defendant Lauren Perry on behalf of Mr. Rochette. Here's his delay.
Please declare on behalf of the Your Honor, Mr. Rochette is scheduled before the court for a final review. The prosecutor deferred sentence. He did complete all terms of the court. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation.
No objection.
So ordered. So, okay. So she told me to pass the 2 cases. I told her I passed them to the end of the block. I'm at the end of the block. And she walks out.
I think she went to call Mr.
Why are you trying to save her?
Soliet.
Why are you trying to save her?
I will happily second.
I appreciate you covering her, but
Or I'll tell her that you're ready.
well, no, I can see her. She's right outside the window.
They'll stare.
Is she on the phone?
Yes.
She's on the phone? She's probably not even talking to them. She's probably calling for lunch.
I hope so.
What is she looking at me like that for? Because if Grubhub shows up, we know what she did.
He's ready. Have you met her? You're past.
I told them, Miss Coons, I told them, give her time. She's trying to work through it. They're all like in a rush.
Oh, yeah?
That's the way I saw it. I'm just telling you. I was gonna all the time you need.
As for Miss Jones, I have not been able to get in contact with her.
Would you like me to call that one?
Yes.
Okay, thanks. She just was gonna launch right in. Court does call the case of the People versus Susan Jones, recall.
Your Honor, as to Miss Jones, I have not been able to get in contact with her today. I did talk to her yesterday. She is a 6-year-old who requires 24/7 oxygen. So I don't know what's causing the issue, but I think that may contribute to it.
All right. I'm gonna tell you what just went through Judge Simpson's head. Yes, I understand what the defense attorney meant when she said she has a child that requires 24/7 oxygen. But here's the problem that goes into my head because I'm a smartass. We all require 24/7 oxygen. Like that that was just not a good way to say that. She has a child that requires 24/7 oxygen. You know what? I'm gonna start using that on everything. Oh yeah, my kids require 24/7 oxygen. Like they require that. Yeah, we all do. We all do. While I'm paused. Thank you so much, Mary Brown, for the $2 super chat. Happiness is a choice. It is a choice. It is a choice. But it's hard to overcome frustration and sadness with happiness. So, it's a battle. It's a battle. It is a choice, though. You are absolutely right. And thank you so much for the super chat. Sparkle Poots, thank you so much for the 5 gifted memberships. And welcome to the family, to all the members that received them. All right. Let's go back and try to recover from the 24/7 oxygen line.
Oh, man. You did. Said issue mentor? Okay.
I gotta zealously advocate.
What?
I gotta zealously advocate.
No, you are. You are doing that. And February 28th, 2024. What time?
At 1 p.m.
1 p.m.
Thank you.
If she's not here, I'm taking both of you.
I will make sure she's here or try to.
Court calls the case People versus Lawrence Saliat.
He should be on Zoom now. Mr. Saliat, if you're on Zoom, if you can unmute yourself and state your name.
He's not here.
I did just speak to him. He is supposed to be logging in.
You're killing me, Coons.
Gunnar, are we able to adjourn this matter?
Oh, so now. No. Just no. What I will do, however, it would be so much easier if I didn't like her. You want me to issue a defense warrant?
Don't look at me.
All right. I'll hold it and call it in the next block, so you can try to get back through to your client or whoever you were talking to out there
Thank you.
and get them on Zoom.
Thank you.
You're welcome.
I appreciate it.
Because see, I said you were talking to your client. They talked about you like ordering lunch and stuff. And Franny said, I hope she is, because she owes me lunch or something. I mean, it was a whole story she had. That's what you heard that, didn't you? Yeah, okay. So that's it for that block? Okay. I'm so done. So I'll court to stand in recess and we'll come back.
All right. Yeah, that was a fun little interjection, right? Nothing really happened, but Judge Simpson having fun with the attorneys, it's always funny. It's always funny. The 24/7 oxygen comment, though, I still can't get out of my head. I'm going to use that. Can you imagine? My daughter has a disability. She needs 24/7 oxygen. Oh, I didn't realize that. Okay, yeah, okay. Here. Take whatever you need. Yeah, we all need 24/7 oxygen. We all knew what the attorney meant by that. We all knew what she meant. But words are important, right? And that was, just the way she phrased it's funny. All right. I think we have one more clip. I'm ending the night on a feel good clip. We got a feel good clip to end the night, but I don't think it's yet. And I think we're going back to Washington, actually. No, we're not. We're actually going. I wasn't. No, I was. Judge Washington.
Matters.
All right, let's go.
Mr. Lebo?
I've actually got a case out of the state of Washington after this one. That's why I was like, oh, wait, no, I can be right on both parts. But all right, let's go. You guys are all awesome.
Thank you, Your Honor. Here we are hearing the defense's motion for a bond reduction for personal bond. The first issue I'd like to raise, that the court is aware of, that the sentencing date is set quite a while out into March, and that is why we're.
I did. I saw it in McConaughey today because you brought me onto it, but I missed I wasn't able to grab the first appearance, so I was just watching for entertainment rather than trying to run it because I missed the clip. So yeah, they removed it before I finished it, which sucked because it's a really interesting case, and I would love. That's the kind of case I want to bring in front of Judge Slavin. It's not a dramatic case, but it's very fun legalese case, and a lot of things happened. Also, it was terrible. All right, let's go.
Seeking this emergency bond reduction, I do not believe that Ms. Ellis is a flight risk or danger to the community. I would note that there is no objection to 7411 in this matter, and that Ms. Ellis tells me that she's very much hoping to be out of jail so she can be with her daughter on her birthday, which is tomorrow. She's going to be happy to attend any and all treatment that the court orders and is happy to comply with any and all testing requirements or a tether requirement if necessary. She does have an address she provided to me where she is able to be tethered under home confinement if the court deems that necessary. And I'd also note that Ms. Ellis has been in custody since January 31st, and she does now have an understanding, given that she's been in custody for a while, of the very severe consequences that occur if she misses the court date or fails to comply with the court's order. So for those reasons, I believe that a bond reduction to a personal bond would be appropriate.
Response, please.
Your Honor, I want to ensure that I make a record of some of the background and reasons why Ms. Elledge is still in custody at this time. She is in our court for two separate matters, as Mr. Lebo mentioned, for a sentencing that's not scheduled for today, but in March. That sentencing is on a reduced charge of cocaine possession, which was taken down to a misdemeanor use, and as well as a misdemeanor case for larceny in our court. So that's been pending at around the same time. Ms. Elledge was originally arraigned on that controlled substance case, March of 2023, and she failed to appear after that. I understand and I'm well aware that her failure to appear at that time was because she was actually transported to Wayne County Jail, I believe. And so I don't attribute that to being her fault for being in custody for her next PCC. However, I was also present when she was arraigned on that warrant and we cleared that issue up. For some reason, Ms. Elledge had never been given a testing order on that case during her first arraignment, and the magistrate Fink would not give her a testing order at that time, even though there was actually an admission essentially to having used during that period. The misdemeanor case that we have for larceny is actually the only case a testing order was on this entire time that I can see. Unfortunately, right after Ms. Elledge was given that PR bond, after that second arraignment, where it wasn't her fault that she was in jail, she disappeared right after that, didn't appear for the PCC April 6th of 2023, and has been MIA ever since then until she was taken back into custody, arraigned on that bench warrant, and she pled guilty to that count of February of this year, almost a year later. So at her PCC, when I saw her take the plea, she offered that she just essentially plain forgot, and I don't understand how that's possible to just forget that you have court in two cases after you were just arraigned on them. So I'm concerned about a failure to appear. I don't think that she's necessarily a danger to the wider community. I think she's a danger to herself, and we want to ensure that her drug use is addressed and treated and tested. She has never tested, to my knowledge, either. With the testing order that's been in her for over a year now, I don't see any results whatsoever. It's just failures to appear for that. So given that it's been a very long time where she's failed to appear, I'm not sure that release with PR on a tether is going to work. We have had individuals Ms. Elledge?
Ms. Elledge.
I'm sorry.
What did you say?
I do apologize. I do apologize, ma'am. I apologize.
What did you just say to me? Oh, I wish we knew what she said. Don't do that. Don't do that. You're already in trouble. You're in jail. Don't talk back to don't talk back to the judge. Don't do it. Don't do it.
Apologize for speaking.
So my concern about tethers is that they're not people proof. And we've had individuals in this court who've been released on things like home confinement, GPS tether, who have cut them off right after getting released on PR bond, who have made plenty of problems. I'm not saying that that person is Miss Elledge, but we really can't guarantee that. And we do have some concern about flight risk here. So I understand that her sentencing date is March 7th. That's quite a ways out. I have no problem if that date can be adjusted to be moved up sooner, if anything can be done to get whatever sort of assessments or interviews that she needs to get while she's in custody to try to help expedite that process. But I'm not confident that we're necessarily going to see Ms. Elledge just come back here or do the things that she needs to do out of custody to get sentenced. I'm also requesting of the court that for confirmation or an order, if one needs to be entered, for testing on the case that she's going to be sentenced on, so that I can ensure that it's applied to that case, because I'm still not sure if one is on there. As for her misdemeanor case, I actually plan to dismiss that matter. I didn't feel like there was sufficient evidence to support the charge, and I don't have any problem dismissing that as long as we can ensure that there is an active testing order on the case that remains. I'm sorry, that was a mouthful.
Thank you. Anything further from you, Mr. Lebo?
No, Your Honor.
Thank you. As far as Ms. Elledge's appearance and absconder status, in the case that is going to be dismissed today, she had a bench warrant on February 23rd and then April 23rd. So she's had at least 2 bench warrants in that case. And then on the case that was reduced to the misdemeanor, she's had the bench warrants that were mentioned in those cases. So in terms of her being a flight, there's obviously some concern regarding that. The bottom line, though, is we're talking about a controlled substance use matter. And it seems like what her issue is that she needs to get that under control, whether she wants to or not. Bottom line past that is that if she doesn't want to, she'll never get it under control on a long-term basis. So, Ms. Eldridge, you got to decide whether you want to get this under control. I'm sorry, what?
Did you want a response, ma'am?
Yeah, that would be.
Oh, okay. I didn't know. I did a lot of praying while I was in here, because my usage, and I have family that are addicts, and I had lost a lot over the past few years, and I had dealt with a lot, but I had to dig a little deep. I have been reading these books while I've been in here this little past month, and my Bible, and I figured out a lot. I had to admit a lot to myself about why, because I didn't have no bad life, no nothing like that, and I wasn't no big user neither, and I'm like, well, why are you even starting that path to begin with, and I dug a little deep, and I prayed about it, and I figured those things out. I'm ready to start back my life, because this happened overnight, man. This is not years and years of usage and years and years and years of usage. I actually had an addiction, which was alcohol, and I was put on a tether, and I'm a witness. That lady, that was her opinion, but ma'am, I went cold turkey. I don't drink no more. And I was an alcoholic. I wasn't a cocaine head. I was an alcoholic, and they put me on a 5 tether for 6 months. I could not use alcohol for 6 months, and I don't use to this day, and that was 2.5 years ago. So I don't believe that is true. When you fix your mind to something that no matter what somebody else defines and says that you can be whatever you say you want to be or what you don't want to do. And my children need more than me, because I've lost everything, Your Honor. I mean everything. So, and I mean everything, including my freedom now. So, that does not mean that I say different. I really do. So, and I don't want to be in here no more, because I'm not an animal. I've had, I've done wrong, yes. I have. But I didn't do wrong because I wanted to, because that's just something that I just had lost control. You know what I'm saying? Not having support. Or feeling like I needed somebody to be able to do right. You know what I'm saying? Or needed somebody to be able to get back my things that I lost. You know, so I just had lost a lot, but right before I came back in here, I had gained a lot more things back in my life. So, and I have a support system. So,
Okay. I'm gonna grant the motion for bond relief. I'm gonna allow her to be on a home confinement tether with testing 4 times per month.
Thank you, Your Honor.
Ma'am, you need to report to community corrections within 24 hours of your release. You're gonna get the tether before you leave, but you need to begin the testing after that.
yes, ma'am. So I get to go home today?
I hope so.
Yeah. Thank you, Your Honor.
Said.
Huh?
I hope you mean what you said.
I did. I mean every last word.
And
I mean that to myself, not to you, man, to you, my Lord and Savior, because I got shown a lot of things. You know, I have been got shown these things. It might sound crazy, but I got shown these dreams when I was younger in my life. Here where I'm at now, you know what I'm saying? It messed my head up a little bit because it actually came to pass and it's scary, you know. You know, and I watch people die. You know, I watch people and I don't want to be that way. I don't want to come out and then use again and die. And my children is left out here without their mom. My daughter is turning 2 tomorrow, and that's one child that I actually do have in my life. You know, I have 5 children and I don't have none of them. And it wasn't even because I was an addict. It's because I hadn't found myself yet. So, you know, I'm working on it. It's a self thing. It's not drugs. It's not alcohol. It's really a self thing. I need to go see a psychiatrist. Maybe.
At least you know it. So
yeah, it's
work
a
on it.
self thing.
All right.
It's a work in progress. And I'm gonna tell her I ain't crazy. I ain't about to cut it off. I'm not gonna cut it off, no.
Well, if it is, it's a felony, just so you know. You don't want that
Okay.
in your world.
We don't want that. No, ma'am.
All right, I'm gonna leave the sentencing where it is. It's currently scheduled for March the 7th, 2024 at 10 o'clock a.m. It's gonna remain that.
But I am released on tether.
Home confinement, so you have to stay at home unless you have a job, and you can go test. Okay.
Okay.
Ms. McDuffie, as to case number 23S0005.
So if the confinement is a confinement center, does the box get placed at home or is it GPS?
It's at home, ma'am.
Okay.
Ms. McDuffie, as to 23S00058.
Your Honor, given that a testing order has been entered on the other matter, the people will move to dismiss this case.
Thank you. I take it there's no objection.
No, Your Honor, thank you.
This isn't the feel-good story. The next one's the feel-good story. It's the next clip. It's supposed to make you feel better. Make you feel better about society. It's not a feel-good story, but I'll explain more in a minute.
Case number 23S00058 is dismissed. And then on 20W003404, that one is just here for fines and costs, which obviously you can't pay since you're in custody at this time. I'm going to adjourn that one to the March 7th date as well. March 7th, 2024 at 9 a.m. Wait, 1 second. Let me see what time I set the other one for. It should be 10. They should all be at 10. Yes, at 10 o'clock. I'll see you here at 10 o'clock a.m.
Thank you.
You're welcome. Don't let yourself down or me down.
Huh?
Let yourself down or me down.
I'm not Judge Washington. Thank you so much. Thanks.
All right. Well, we got your sweet. Yesterday, your sweet voice acted like a low boy. I fell asleep. Oh, well, thank you. I appreciate it. I appreciate it. And I want to say thank you guys for lifting my spirits up a little bit. Like I said, rough day. Just I didn't want to do a live tonight. I really didn't. But yeah. That's why I didn't do a premiere or anything today. I just wasn't into it. So that's why most of these clips are old. I just wasn't court hopping as much as I usually was. That's a different story though. Anyways, I want to thank you all for being here. You guys are all awesome. All of you are awesome. Thank you all for the gifted memberships, all the super chats, and for Sly with the PayPal. Still the best way to super chat. If anybody wants to do that, that would be very helpful, and I'd be very much appreciative of it. But anyways, this last clip though, it's gonna change your mind about. No, it's not gonna. I'm not gonna promise that. But hold on. You know what? Let's just play it.
Ms. Pimentel permission to put an X on the signature line on that document on your behalf. Is that correct?
That's correct.
And did you have an opportunity to read or have read to you the entire document prior to deciding to enter into this plea?
Yes.
Did you have a chance to go over it in its entirety with Ms. Pimentel?
Yes.
Was she able to answer any questions that you had about the document?
Yes.
I've got multiple videos ready to go. I'll play another video. I will. If you guys want to hang out longer, I will play another video. But I have multiple videos ready. This was just my life for tonight. And this is still this clip I think is about 20 minutes long, so we're nowhere near finished.
You have any questions for me about it?
I do not know.
All right. Well, we're going to go through this together, starting with paragraph 1. Is it? Do you pronounce it Jamarian?
Jamarion.
Jamarion. All right. Is Jamarion Marshall Johnson your true name?
Sean Johnson. Yes.
Okay. And are you 19 years old?
Yes.
It's the highest level of education you've completed, some college.
I'm a junior in college. Yes.
Okay. Paragraph 4 indicates that the crime you're charged with is one count of theft in the 3rd degree. The elements of that crime were set forth in the charging documents that you received. Did you go through those elements carefully to make sure they accurately describe the crime you intend to plead guilty to today? I'm sorry, I need you to answer out loud because we record this.
Yes.
Okay. Paragraph 5 sets forth the constitutional rights that you give up by pleading guilty. They include the right to a speedy and public trial by an impartial jury in the county where the crime was alleged to have been committed, the right to remain silent before and during trial, and to refuse to testify against yourself. You have the right to hear and question any witnesses who would testify against you. You also have the right at trial to testify and to have witnesses testify.
I knew that was coming. I honestly did. The second I started playing this, I'm like, oh no. Yeah, I knew it was coming. All right. We're going to fast forward a little bit. Don't worry. I fast forward and it rewinds.
Guilty today, you will be giving them up in this case.
Yes.
Paragraph 6 sets forth the consequences of your plea. Did you go through those carefully?
Yes.
Did you make sure that the prosecutor's recommendation that's written in paragraph 6A accurately reflects what they said they were going to recommend pursuant to the plea agreement?
Yes.
But you understand as the judge, I don't have to follow that recommendation or anyone's recommendation. I could sentence you to anything up to and including.
I don't really understand that comment. When I admit to knowing the YouTube rules, you'll post. I mean, I like to think I know the YouTube rules, the rules. That's why I pause during video and put my voice in it to make the videos. I can't think of the word right now. What's the word? When you make the videos, you change them enough where the YouTube algorithm doesn't think that you're just taking the clips and making them and just redistributing already. Yeah, it doesn't matter. But thank you for coming to hang out.
The maximum allowed by law, which in this case would be 364 days in jail, a $5,000 fine, and 2 years of probation. And if I did that, that would not be grounds for you to withdraw your guilty plea. Do you understand that?
I understand.
Also understand that if you are not a citizen of the United States, this plea could have immigration consequences.
Yes, I understand.
Did you go over all of these consequences with Ms. Pimentel?
Yes, we did.
All right. And Ms. Pimentel, did you discharge your duties pursuant to Padilla and Sandoval?
I did, Your Honor.
Mr. Johnson, has anyone made any threats or promises other than the prosecutor's recommendation that's written in paragraph 6A to get you to plead guilty today? And that didn't come through with audio for me for some reason?
No, it did not. No, they did not.
All right. Are you doing so freely and voluntarily then?
Yes.
All right. Paragraph 11 is a statement in your own words of what you did that makes you guilty of this offense, and it reads as follows. On November 26th of 2023, in the city of Bothell, Washington, I did wrongfully obtain various items from Rite Aid with the intent to deprive Rite Aid of the value of the items. Is that a true and accurate statement?
Yes.
Do you adopt that statement as your own?
I adopt that statement as my own.
Then to the charge of theft in the third degree as charged here under this cause number, how do you plead?
I plead guilty.
Guilty plea will enter. I find it's knowingly voluntarily made and that there is a legal and factual basis for accepting the defendant's plea of guilty. Does the city have anything to add to its recommendation?
Nothing to add, Your Honor. This is an agreed recommendation that the city is simply requesting that you follow.
Thank you. Ms. Pimentel.
That's correct, Your Honor. Obviously, you can see there's a lack of history here. He's a very young individual, and we are hoping that you'll give him an opportunity to be able to ultimately have this dismissed off of his record. Because he is a full-time student, I would also ask the court to waive any non-mandatory fines and costs.
All right. Oops. All right, Mr. Johnson, I'm just taking notes because I have to close this screen and move to a different one. So, all right.
Thank you so much, Wild Horse Guy, for the 10 gifted memberships.
And I want to give you my full attention. So give me just a moment.
You know what? That's a good point. I know there's a little bit of a pause coming, so I was trying to talk while she was paused. But that's a really good point. Wild Horse Guy, I'm going to give you my full attention. Thank you so much for the 10 gifted subs. Very much appreciated. Very kind of you, and welcome to all the members. Members only content every Monday.
Here. All right. I want to get my computer working towards that next thing before I start talking to you so that hopefully it'll catch up. All right. Give me just a moment.
And there is a point to why I'm playing this. I know we're starting with the boring stuff, but you got to hear the case first.
All right. So this is your opportunity to tell me anything that you would like me to take into consideration before I pass sentence. There's a fancy legal term for it. It's called your right of allocution.
There's nothing that I'd like to say on my behalf.
All right. I do see that there appears to be someone here on your behalf, sir. Did you want to say anything, or are you just here to observe?
All right, so we're gonna find out that this is Dad, and listen to this dad's speech. If this doesn't give you goosebumps, then you probably don't have kids. But this is probably the man. If you're in jail, this is the person you want showing up on your behalf, and this is his father. This is an amazing speech. So get your popcorn ready, get your Coca-Cola, and just sit back and enjoy this speech, because he cares about his son, and he knocks this speech out of the park. All right, that's all I'm going to say. Let's go.
Oops, your microphone is muted. There we go.
Yes, I would like to say something. Jamarion is my son, and I just like to give the court a little history on Jamarion. Right now, Jamarion, he is struggling right now, within himself. And I'm his father, and it's my sole duty to help him in this situation. I feel so bad that he's in this situation at 19 years old. We just recently had a death in our family, which was my father. He's struggling with that, and of course I am too. And my mother just had a serious battle with cancer. She's 80 years old. We're struggling with that, and she's surviving that, and this is tearing her apart. And this is so unfortunate that it's my duty, my sole duty, to get Jamoria to understand, the things that adults take on are very serious, and these things can destroy you along the way if you don't conduct yourself the right way in American society, especially as an African American man in these trying times right now that the country is going through. I'm here to help him. He has my full support. He has a home to come to. Right now, I'm my duty in life right now. My work as far as what I do in work is I work in the Mexican consulate right now, and so it's a high level position. I have a lot of things that I do, but it's not an excuse. I need to find more time to spend with my son. And in doing that, I probably need to bring him to work with me so he can see the things that I do on a day-to-day basis that help people instead of hurting people and stealing and fighting and lying and cheating. All those things are not going to get you anywhere in life. And the battle is not with, I would say, things that he wants. The battle is within himself on how to obtain those things. And it's my duty to teach him and show him and guide him for the rest of his life and the rest of my life on the planet. So in moving forward, I would like the court to just consider just some of the things that I'm saying, even the fact that he's struggling within himself with the LGBTQ thing that he's struggling with. It's a battle between him and his adolescent cousins. They don't accept it. He doesn't understand why, because they all grew up together, that people are different, and that's just the way life is. And so if you look at his record, that's basically what he's been doing. He's just been fighting and fighting and fighting, but it's with his own family. And so I'm just deeply hurt, and I'm going to do everything in my power to help him to just get over that threshold and just walk into adulthood where he can be able to financially obtain those things that he wants. He wants a car. He wants nice clothes. He wants jewelry. He wants all these things that young people have. And you can't take those things. You have to work and save your money and buy those things little one by one, step by step. And so I'm going to do that. And I want the courts to know I'm going to do that. And I want Jamarion to know that I'm here for him always. I love him. I mean, he's my son, and I love him. And like I say, my mother's deeply stressed out, and I just want to bring her some good news instead of bad news. And I just want him to be free. He's 19 years old. I don't want him to go down that road, and the next thing you know, he's sitting in front of you with a felony. Because if you look at the record, he's headed down that road. And I have to really get him to understand that. And I believe in my heart that I will be able to achieve that, along with the help of my family, my brothers and sisters, his uncles and aunties. We're going to rally around him, and moving forward, bring the best out of him. He just graduated from high school, from Cleveland High School, and from graduation from high school, he obtained a 2-year degree. He was going to college in high school at the same time. So he's not illiterate, bad child in no means, not at all. He's very smart. He's very intelligent.
All right. I thought this was a good speech. No one else reading the chat, everyone's against what I thought. I was thinking that dad showed up for his son, and I was really proud of that, and I was excited for him. And yeah, but you guys don't seem to like this clip, so we're gonna call it a night after this clip. So I'm gonna let it play out. You guys have a great night. Till next time. Bye.
It's just inside of him that he needs to understand that you have to control your anger and you have to work. It's time to start working to obtain the things that you want. Plain and simple. So whatever it takes moving forward to help him, that's what I'm going to do. And I just want the court to know a little history on him. He lost his mother at 18 months old, and it's a child sitting in front of you that has never been held by his own mother. So he doesn't. It's something that I have to go and seek help out with a professional, sit down with somebody, with me and him, not just him by himself, so that they can explain to him what he's going to, and maybe if somebody else tell him instead of me, he'll be able to gravitate to it and be like, okay, I understand what my dad is trying to say to me. And that's what I would like the court to know, just that little history about Jamorian. So moving forward, he can do something better in this society. Even he can look at me and just be, I want to be more of a role model to him. That's why I get up and put a uniform on every day. That's why I'm a public servant. That's why I do every single day things to help people instead of hurt people.
Thank you, sir. So, Mr. Johnson, who's before me for sentencing, you're 19 years old. And even though I have a whole lot of gray hair, I remember being 19. And I know I, as a grandma, I have a great compassion for what your dad has told you, but I also remember that at 19, I was kind of like, hey, I need to live my life, right?
Yes.
Which I completely understand. You do not understand, because you haven't been where I am, how important it is that your dad is there for you. Do not take that lightly. There are a lot of people out there in the world who do not have that support. And your dad is absolutely right. You have choices to make here that could lead to spending a whole lot of time talking to people in black muumuus, which usually is not people's favorite thing to do. Or you can go down a different path. My older boy did the same thing, 2 years of college and high school. It's a great program. I'm really glad he did, because he was not the person who got along very well with everybody in high school. He'd got along a lot better with people in college because they were more serious. I bet that's the same thing for you, right?
Totally. Yeah, it really is.
Yeah. So when you're doing those decisions and you're making those choices, you've got a whole lot of stuff going on. I don't want to see you back before me, and I want to see you succeed, right? So I do want to see you back, because I want you to come back and say, look what I've done with my life. That makes my life wonderful. But I don't expect you to do that. All right. I'm hopefully a momentary glitch in your progression through life. As far as my impression, you have always been very articulate and well-spoken and polite in court. So I very much appreciate that. I don't always get that. And so I have no question that you can succeed. It's a question of what you decide to do. All right. Your dad has made a tremendous amount of offers of support. I really do encourage you to take him up on it. It is the difference between how a parent loves us and how other people love us is very dramatic. I also understand, because I also lost my mom at a young age. It's a very difficult thing, but it's not insurmountable. You have a core group of people who love you. You probably, from what it sounds like, you have a few of them who are being what family members will be, right? You don't always get along with everybody in your family, and yet there's that bond of love. I tell my sister periodically that I love her, but I don't really like her very much right now, right? There's that. But you will always love that person, and that's where it goes. So that's my lecture, and I'll stop now because we do need to get you going. And I'm going to follow this recommendation. You've got some other judges you're going to have to talk to, and let's hope that they also feel that this is an appropriate way, or that there is an appropriate way to keep your record clear, or as clear as it can be, for the future.
Sorry, guys.
Okay?
I don't know what's going on with my internet. It's skipping on my end right now. Hopefully it's playing for you guys, but it's skipping pretty bad right now for me.
I would like I said, I'd like to see you succeed. I will also tell you this. There are people that I know who have done extremely well in their lives after making mistakes in their youth. And I will tell you about one of them, which council have already heard before, but there's a gentleman that I know who a few years ago got to ring the bell on Wall Street. He started a business that was so well appreciated by the powers that be at Wall Street that he got to ring the bell. It's a big deal. When he was 18 years old, he got convicted of a federal theft charge for stealing a picnic basket in a federal park. He and his buddies were wanting to get beer. All right. Buddies were 17. They were treated as juveniles. No big deal, but he got the federal conviction. You get a federal conviction, you can never get it off your record. So now he's running a multinational, multi-billion-dollar corporation. He's circumnavigating the globe every 2 weeks, meeting with people, negotiating these giant contracts. And every time he gets on a plane to leave the country, he has to explain that federal theft charge in front of clients often. All right? But with that, he still succeeded. All right? All right? So what I'm telling you is don't let these things keep you from succeeding. All right?
Right.
All right. So with that, I'm going to follow the recommendation. I'm going to impose 364 days in jail. I will defer 364 days, which means that you have the opportunity, if you have no new criminal law violations in the next 12 months, that conviction will leave your record. Actually, I'm deferring 360 days, giving you 4 days to serve, but credit for 4 days served. Sorry. $5,000 fine. I'm deferring the entirety of the fine. Even though dad's working fully, you're a student. I'm not putting legal financial obligations on dad for you. All right. I will make finding of indigency and waive any non-mandatory costs, fees, and assessments. The conditions of that 12 months, the way that if you follow, that keeps you from having this go on your record, is what I said: no new criminal law violations. Keep your address up to date with the court, because if I think something's going on, I'll send you a notice. You're going to want to get that notice because you don't want to talk to me the way we're doing right now, right? Even though Red's.
All right, you guys want another video? What do you guys think? We've been going on for a little bit now. It's about an hour and 20 minutes. So, if you guys want another video, we can play another one, or we can just call it a night. You guys decide.
A good color on you. Probably not your favorite to wear something else that somebody else picks out for you, right? So it's not as bad as the stripes that I see. We'll put it that way. You're going to have no contact with Rite Aid. All right. And if they've issued a trespass order, it's going to be all Rite Aids. So don't take a chance on that. I think that's pretty much everything that, they want you to take a consumer awareness class. That's right. So we'll do the consumer awareness class. Get that done. I'd like to have you get that done within 60 days. All right. Can you do that? That's 2 months. Okay. And I think they're still online, so it should be fair.
All right. I'll play another video. This one isn't ready, as in I've got some editing to do, but yeah, whatever. It's still a good video. I think this is it. Hopefully I get the right one. Yeah, we don't need to hear the intro again. We've already heard it twice tonight. Yep, this is it. This isn't clean, so I might have to fast forward a part. All right, let's go from here.
Thank you. Counsel, can you tell me what?
Oh yeah, Judge Shackelford mutes herself a lot during this, so every time she reaches her hand back, like she is right now, she's muting herself. But yeah, we get all the good stuff. Don't worry.
We weren't zooming on
about the communication. What is the best? What do we?
You know what?
I forgot.
All right, this is 2-4.
I forgot that I got to turn the volume down, the master volume down when Judge Shackelford's on because she's so loud. Like I think her mic's right in front of her mouth.
40078. Strike that. This is 2400081. The People versus David Martinez.
May it please this honorable court, for the record, Marshal Garmo appearing on behalf of defendant David Martinez, standing at my right. Your name, sir? David Martinez.
All right, Mr. Zick.
And good morning, Your Honor. For the record, Matthew Zick for the People. The victims are also present in the courtroom.
All right, I see that. Counsel, as to arraignment.
My client will plead not guilty.
All right, I'll enter a not guilty plea on his behalf. We're gonna set some bond conditions here.
Your Honor, my client takes this very seriously. He came to my office here. I'm a American attorney. The facts are not everybody will agree on what happened on that day. That's why I need discovery. I need the police report. I need if there's any video, anybody can. I need them before I can move forward with this case.
Okay, so what we're gonna set we'll adjourn the hearing today so that you can obtain discovery. As to bond, Mr. Martinez, you're to appear in court as directed. Unfold your arms. There you go. Not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot have any contact with complaining witnesses on this case. They are Irma.
I'm sorry, Your Honor.
It's Irma and Joseph Erdan, Your Honor.
Yeah, okay, I've got it. Erna and Joseph Erden. Is there something you need me to know, counsel?
Your Honor, I'm requesting a personal bond. He came here on his own. He hired me, and we want to move forward with this case.
Okay, I'm gonna grant him a personal bond. He has $1,000 personal bond, but we do have these conditions in place. And they are, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number so we know where to send your court notices to. You're not to have any contact with Irma and Joseph Erden or their home or employment. And we will adjourn this out approximately 30 days for discovery.
Yes, Your Honor.
And I'm going to go ahead and sign a discovery order now for you. And that way you don't have to contact Mr. Zick or work on getting that. You'll have that right here before you leave the court, okay?
Yes, Your Honor, I have a request. Is it possible?
All right, we gotta get all the boring stuff out of the way before the exciting stuff happens. So now you know this guy did some things. He has a PPO against him. Now, the next couple minutes, yeah, it's about to go down.
To have a mutual no contact order, because my client and his wife is outside, by the way. He's so scared that to the point that he wants to move out and go to a different city.
Okay, but here's the thing. I don't have any
every day
sir,
by these people.
Sir, I do not have any authority over complaining witnesses in a case. I can't give a mutual restraining order. I don't have the power to do that. I have no authority over the complainants in this case. I mean, obviously, if there's some harassment going on or some other issues, I think you call law enforcement. But you're the individual charged with in this case. These are just allegations. You have a right to trial. You have a right to be proven guilty beyond a reasonable doubt. All of those things apply. I'm sure your attorney has discussed those rights with you. We will make sure that this case moves through the system. I mean, it's in everybody's best interest while cases like this are pending because the situations are always volatile. It's an assaultive allegation that everybody stay away from everybody. Okay, but I don't have authority over complainants in the case. I only have jurisdiction over Mr. Martinez. So Counsel, if you just want to have a seat real quick, we'll have the court officer make you a copy of this order for discovery so that you can get discovery as soon as possible. And we will see everyone back in about 30 days.
Thank you, Your Honor.
1 second. And counsel, can I get your P number, please?
37394.
37394. Okay, thank you. Give us just a second, and if you could just make him a copy of that top page, officer. All right. And then when the parties leave, if the complaining witnesses on this case, if you want to excuse yourself now and go out and you can get in your cars and leave, and then we'll just have Mr. Martinez wait a minute or two, and that way there are no issues in the lot, okay? All right. Yes.
Say something. He walks right in front of my house all the time with the dog. There's no reason for him to do that. He could go either way, but doesn't provoke me and say things.
All right, you two have got to be living in the same neighborhood.
We're across the street.
Listen.
He just gave me the finger when we were out there and I was sitting down.
Listen, I want you to talk to the prosecutor.
Okay.
Listen.
I will.
This is unfortunate because you guys have to live near each other, right? And I don't know if you're homeowners or what. Listen to me, ma'am. Listen, first you have to say your name for the record.
My name's Irma Hurden.
Okay, listen. If he lives right across the street, he's got to exit and enter his house, right? Don't go listen, Mr. Martinez, everyone do your best to stay away from the other side. Don't flip each other off. Don't talk to each other. Don't look at each other, okay? That's all I can tell you. But I won't have the volatility in my courtroom. This is when I say my courtroom, it's the people's courtroom. This is your courtroom. Everybody's entitled to have due process and a hearing, and whether it's a trial or you know, depending on a formal hearing, depending on what type of hearing it is, everyone has a right to be heard, but I'm not going to tolerate, you know, everybody has to deal with each other. If you live that close to each other, that's all I can tell you. Don't go near each other. Avoid each other like you have the plague or the other person has it.
Okay, I got a question. Now, when I walk my dog and he's following me, sneaking up with his lights off, coming behind me. So what do I do? What am I gonna do about that?
Calm down. Sir, you were in a courtroom. Listen to me. You guys calm down. Stay away from each other. You're going to end up with everybody charged. You're going to end up with things like this. Get the volatility. It's going to just escalate. Sit calm. Listen, I'm telling you all, stay away from each other. Don't look at each other. Don't follow each other. Don't talk to each other. Don't breathe near each other. Both sides. Got it? All right. Yes. We're all set. I'm going to ask the complaining witnesses to exit, and that way there are no issues in the.
All right, don't breathe next to each other. But what if they need 24/7 oxygen? How are they going to be able to not breathe next to each other when they need 24/7 oxygen? Just asking questions. All right, I'm going to fast forward this a little bit. This is a really good one. All right, this is the last clip. Yeah, I actually remember when I said it wasn't clean yet. I accidentally put my outro as my clip divider. So yeah, it wasn't ready. And I also think that there's a part of this where I have to fast forward as well.
All right. And
you know what? Before I go further into it, thank you so much, Legal Fiction, for the $10 super chat for the OT clips. Yeah. I appreciate the super chat. Let's go. This one's good. This one's good.
okay, so and this is Mr. Haston.
Your Honor, my right to counsel has been denied. Both court dates. The very first one, I had an attorney with me. Right now, I'm asking that this lady in the back be removed for making comments But she shouldn't be in here right now. She's irritating me worse. And not to mention, this is not what my wife wanted last time. She tried telling her that and they wouldn't listen to her. And me and my attorney we're having an issue here that doesn't seem like it's going to be resolved.
Well, I want you first of all to understand that nobody can be kicked out of the courtroom.
Okay.
Okay. That's not an option. The only time somebody can be removed from a courtroom is if they're disturbing the proceedings, and that's not happening here.
Okay.
So we'll move on to the second thing. And reading between the lines a little bit, it sounds like you and Mr. Kale may not be having a productive attorney-client relationship.
Well, Your Honor, meeting your attorney before a court date, that's a right to counsel that was denied to me last time. He ran up here this time after I was told to call him on the phone, which I just still don't feel is appropriate. That's not being allowed by due process, my right to counsel. And I really feel like that if 4 people or 3 people are going to take my wife into a little room over there and talk about some things that I'm not allowed to be aware of, and I'm sitting back here by myself, that this is an unfair situation, especially when I'm the person who called the police for the domestic violence that I'm in jail for, that I called against her. She was arrested 2 months before that
We'll
for
take
domestic
it
violence
take it
against
a little
me.
at a time. All right. First of all, Mr. Hastings, as far as whether the charges are appropriate, whether it's
They're not.
a good or a bad decision to file charges against you, that does not belong to the court. That is the
Yes, Your Honor.
prosecuting attorney's decision,
Mhm.
not the court's. I can't review it or overturn it or anything like that. Okay. So they've made that decision based on what they think is the appropriate thing to do in your case. So we're all going to live with that. But there are 1 or 2 things I can address. One of those is the right to counsel. Certainly, you were appointed an attorney. Mr. Kale's your assigned attorney. He does this kind of work at this court. He's one of the county's public defenders. And he represents all kinds of people. And I've seen him do that on a number of occasions. So typically, I would say that I've never seen him do anything I would consider not appropriate or, not up to standards. So it kind of surprises me a little bit to hear that, but that may just be a matter of perspective. So.
Well, Your Honor, I could be wrong, sir, excuse me. But don't I have a right to counsel?
Yeah, absolutely.
Okay, well, this right here, what happened last court date and what was beginning to happen this court date before he ran over here. That's not my right to counsel, Your Honor.
Well, I don't know. Maybe not. I haven't heard the situation fully yet, so I don't know, but we'll make sure your right to counsel is protected. We're not going to allow.
Yeah, I mean, we'll go all the way to jury trial with this one because I'm not taking any deal at all.
Okay. Well, in your
I
case,
didn't do anything wrong, sir.
Your case is set for trial already, right?
Let's do it. Yes.
You've got a trial date in place. Mr. Kale's been on your case now, I think, since I want to say
10 minutes ago.
January. So I don't know. Well, let me hear from Mr. Kale and, I'll sort of put this together. I may have some questions for you.
Okay, thank you.
Mr. Kale.
Yes, Your Honor. I admittedly had not spoken with Mr. Hastings before today. I missed him when I was going over the calendar and seeing who I had on the calendar today. I do feel like I would be able to take this case to trial by on the 29th and 30th, if that's what my client wants, and if that's how this case plays out.
Circuit Court of County is now in session.
Client wants, and if that's how this case plays out. I think Mr. Hastings and I would be able to, outside of today, if we had a little bit more time, I think we would be able to hopefully communicate effectively. But I only have today to go off of, Your Honor, and Mr. Hastings feels like we have not been able to have productive communications, at least today, then I would defer to the court on that, Your Honor.
All right, well, Mr. Hastings, I guess it doesn't sound, unreasonable to me that you'd be a little upset over something like that. I'm not going to criticize that. I will say, it's unusual. I don't think that's Mr. Kale's typical practice, but people can miss things. That happens. And I know it's not a lot of comfort to you when you're the one who, was expecting to
Spent
have
3
the
days in
lawyer.
jail for nothing. Yeah, that's what I'm upset about.
But here's where we're going from here. I mean, obviously your case is heading to trial. Mr. Kale knows that. He said he thinks he can be ready to try your case for you starting on, it's April 29th. So there's actually a couple of months. And you haven't had a meeting before now. So, maybe it's not appropriate at this point to say that you can't have a constructive attorney-client relationship. Might be appropriate to say that things didn't get off on their best foot, but like I said, mistakes can get made, and we'll evaluate them in context. If we were a week before trial, I'd be upset about it. We're 2 months before trial. A missed appointment is a missed appointment.
And a not returned email, I want to add, because I did what I was told to do by the court paperwork I got
Gotcha.
last time. Said to
Nobody's
call
putting
and
any of
email,
this on you.
and I did.
No, nobody's putting any of this on you. So my inclination here would be to say, okay, let's go from here. You and Mr. Kale do your best. You're going to need to have at least a meeting with him, and you probably get that set up today, and figure out how the trial strategy is going to go and get everybody prepared for trial. And if that doesn't work out,
I'll hire an attorney myself. If we're going to trial, I'm gonna spend the money, because the money is there. And if my wife doesn't like that, then oh well. That's where we're at with this.
Right now, this isn't about her. This is about you.
All right. If you can afford to hire your own attorney, why do you have a public one? You shouldn't have got it. He just said the money's there. That I wish right now the judge would be like, okay, I'm gonna excuse him. You hire your own. It's on your own. You do it now. That upsets me so much.
It is.
This is about your decision to go to trial. So let's keep this in place as Mr. Kale's case. And if you have a problem with them, not now, not for missing an earlier contact. We're going to set that aside.
True.
Going forward from now, right? Then you let us know, and we'll make a decision
Yes,
as to
Your Honor.
whether somebody else should be your lawyer. Now, you're free to hire a lawyer if you want to. If you
Yes,
do that, then
I will be doing that. If that's what we have to do, if we're going to trial, then I will be retaining paid counsel, and I will be retaining paid counsel.
All right. Well,
For
if
sure.
you do, we know how to handle that.
For
You're
sure.
a new attorney.
Yeah, I know, Your Honor.
All right. Is there anything else I need to address today?
Your Honor, defense would be renewing the motion to rescind the no contact order based on Ms. Hastings, the complaining witnesses motion to modify or rescind the order that was filed on January 22nd. I had a brief conversation with Ms. Hastings in the room outside of the courtroom. She tells me that there was no, essentially the conduct that's alleged to have occurred. She denies that anything of that nature happened. She denies that there was any physical contact between her and Mr. Hastings and Ms. Hastings is here today. When I spoke with her, she also expressed to me that she wanted this no contact order rescinded. And so we're asking the court to rescind this no contact order today, Your Honor.
Judge Wilcox did rule on that originally when it was filed, and she heard it on January 31st. But I know Ms. Hastings here, but I don't know what she wants. I mean, she hasn't spoken for herself, or no one has on her behalf. So at this point, I'm turning to you, Mr. Eastwood. If the state or if anyone on Ms. Hastings' behalf wants to address the court, they can. Well, let me start with Mr. Eastwood. We'll go from there.
Your Honor, the state is troubled by this case. We understand that Ms. Haston is not wanting to proceed. She's not willing to participate in trial. I think that puts the state in a position where we don't have many options. However, for the court's information, for defense's information, defendant made a request to have Ms. Cervantes removed from the court. The court addressed that. The basis, I believe, for that request is that Ms. Cervantes relayed to me that she had just heard the defendant violate the no contact order by talking to Ms. Haston, telling her to go speak with Mr. Kale. That's troubling. I think the state is in a position where at this point we would have to dismiss based on Ms. Haston not being willing to participate.
We're allowed to talk and text each other.
Yeah, Ms. Haston, hold on just a second, okay? Let Mr. Eastwood finish and we'll go from there, okay? But, well, obviously, that's your decision, Mr. Eastwood, whichever, if you want to dismiss the charge, that's certainly your right as the prosecutor, or alternatively to proceed to trial.
Well, Your Honor, given that the state is not of the opinion that without Ms. Haston's testimony, that we could make the case at trial, and I think we have discussed the matter with Ms. Haston at some length. Do not believe that she is likely to change her position on this despite any conversations. So the state at this point would be moving to dismiss without prejudice, with the option to refile if anything further happens, and with notice to defense that things will be watched carefully and closely.
Yes, then. Okay, Mr. Haston.
Sure.
As I said before, it's the prosecutor's decision whether to file charges. It's also the prosecutor's decision whether to dismiss them. And as you heard Mr. Eastwood said, he's asking that the court dismiss the charge, and I will do that. That also means that
Why didn't I have a say when the charges were dismissed against her for doing it to me?
That also means that the order that the court issued limiting contact or not allowing contact, that's also going to go away.
All right. So, yep, all that and charges are being dismissed. And then the guy's still arguing about it. He's like, dude, your case is being dismissed. Take your win. Go home. Don't do anything stupid. He doesn't. But this video is over. There's a minute or two left. So I'm going to peace out. You guys all have a great night. Thank you all for the super chats. Thank you all for being here. You guys are all awesome. I will see you all tomorrow. Until then, bye.
All right, I've signed the order dismissing the case, and in a moment I'll sign an order rescinding the no contact order. Now, this doesn't affect any other orders that may be in place, just the order in this criminal case. We'll get you copies of all the paperwork here in just a second, Mr. Haston.
Here's the dismissal order, and once we get
The other one's the one I'm worried about.
exactly, and that's the one that you're.
Yes, sir. Yeah.
Yeah, we'll have that ready for you in just a few minutes.
Thank you, Ron.